All right, everyone, welcome to the Laws of eSign launch event and live session. We'll just cut straight to the chase. Before that, a brief introduction. I'm joined today by Ancha, who is the primary author of Laws of eSign. Ancha, before joining Legality, was a lawyer at Indus Law and LNL Partners before that. I'm Aditya, the secondary author of the book. Before joining Legality, I was a litigator for 3 years in Bangalore. And we're also joined by two esteemed members of the bar, Mr. Gourab Banerji and Mr. Sajan Poovayya. Sirs, thank you very much for gracing this event with your presence. So without further ado, I'll hand over the mic to Ancha to begin. Just a small house rule, if you have any questions, please ask them in the Q&A box in the bottom of Zoom. All right, Ancha, over to you.
All right, thanks, Aditya. Okay, good evening, everyone. It gives me immense pleasure in welcoming you to the Laws of eSign book launch and live session. I thought I was going to introduce our illustrious chief guest, but since Aditya has already done that, but I still wanted to thank the both of you for taking the time out of what we know has been a very busy day for the both of you. So without further ado, and in order to do our best to stick to a 60-minute session as we promised, let's dive right in. Why did we write this book? While a part of it was because we've seen an increasing number of legal queries in the market today regarding the use of electronic signatures in India. The other part of it was the need to simplify the extant body of law on this subject. For whatever reason, there is a perception that the laws on this subject are confusing and also restrictive in scope with respect to the use of electronic media to execute documents. We wanted to simplify and clarify all the confusions and bust a few commonly held myths along the way. A knowledge of the law on this subject is incomplete without an understanding and appreciation of the role that technology has to play here. This book is a result of months spent on consolidating our knowledge relating to the law and technology behind eSigns and presenting it in the most easy to read way possible. While I would have used the word hope, but I'm going to say that I expect this book will answer all your questions when it comes to electronically executing documents. We would be remiss if we did not mention the key contributions of some people who have helped make the book what it is today. We would like to thank Vinodni Srinivasan, practicing advocate at the Bombay High Court, and Suswagata Roy, partner at NKR Law Offices, Delhi, for their support and extremely valuable insights, which make this book a must-have for any modern commercial lawyer. So thank you for that, Vinodni and Suswagata. So let's dive right in and take a quick look at the format of today's session. I will first pass on my virtual mic to our chief guest. After that, we will teach you a useful, actionable framework to evaluate eSign types, which you can then later on use in your legal advice. Unfortunately, no area of law, including this one, can be taught in full detail within an hour. So what we will be teaching you today is how to frame the issues when it comes to electronically executing documents and what are the questions you should be asking. We will share our conclusions with you, which are the answers to those questions. But for a more detailed legal analysis, you should refer to the Laws of eSign book, which explains everything we will be discussing today in much more detail. A copy of it will be available for download right after the talk concludes. So if you miss any part of the talk, don't worry, you will always have the book with you. Additionally, we will also have an open Q&A at the end where we will be taking all your questions. So if during the presentation in the middle you have any questions, please post it in the Q&A section provided at the bottom of your screens. With that, Mr. Banerji, I would request you to please address this gathering now with your opening remarks.
Thanks, Ancha, and thank you, Aditya, for inviting me to be part of this journey. I am not going to talk about the book, but I'm going to talk more about, because I'm sure there are many more competent people to guide you through the law. And I see my friend Sajan there, who actually needs no introduction. So I'm not going to talk about the book. I'm going to talk more about this on a personal level and to highlight really the importance of the book rather than the contents. So you must realize, if you look at the screen, you'll see 3 gentlemen without a tie and one with a tie. And the reason is simple. The reality is that I belong to a pre-liberalization generation. I was in my mid-20s when Narasimha Rao 91 announced liberalization. And in my first 10 years, I remember many aspects which I don't know, many of you would never have seen. Carbon paper, cyclo-styling papers, whiting out drafts because you've not possibly dictated it properly, manual typewriters, and the purpose of this is then to come to really, you know, signatures. And I'll tell you a very nice anecdote of what I remember. This is in the 1990s. I was arguing a case in the Supreme Court. Unlike today, there was no question of any adjournment in a final hearing. So I was briefed as the junior. There was a distinguished senior, Mr. X. You can guess who it is later. I started arguing. The judges were listening to me patiently. It was a final hearing. The gentleman in question came in about 10 minutes later. He sauntered in his inimitable style. He sat next to me. And he sat next to me like this. And I said, sir, would you like to take over? He said, no, please continue. So I continued. So 10 minutes into my argument, he sort of taps me on my shoulder. So I thought, you know, I've obviously messed up badly. He taps me urgently on the shoulder. So I turn around, the judges are looking at me, judges are looking at him, and he pulls out a pen from his pocket. He says, Gourab, look, I have bought this new pen. This is what I'm going to sign my bills with now. Judges are looking. I was completely stunned. It took me literally a minute to get back on. But I mean, the deal here is that there is a sort of sanctity amongst lawyers attached to paper and pen and signatures, and you know, somehow, at least generationally, we feel, you know, if you have a piece of paper in front of you and a hard copy, it is really, really important. So let me divert from this and let me go to legality. And I remember meeting Sajan in 2015 for the first time when he wanted to go to NUS, Singapore. And he met me then he was in NLS. And then 2019, he came and pitched this idea of legality. And frankly, I was really skeptical. As Mr. Jaitley mentioned to me many years ago, I was born old, according to him. But anyway, be that as it may, I was a little skeptical. He had no background in running a business. He was an NLS lawyer, whatever that means. I can see lots of NLS lawyers here. But he sold me the idea, and I'm proud to say that I mean, he and Shivam was there, and obviously you guys have taken it far. But I think the pandemic has changed everything. We have been willy-nilly forced to enter into you know, the electronic world, and obviously electronic signatures are vital. And having sort of read this and having had this explained to me, one now realizes that one can't really be stuck in the 19th century, though I'm from Calcutta, where they still use mechanical typewriters. So I mean, I will soon hand over to Sajan, who's a 21st century person. But the reality is, the takeaway point is that you have convinced even people like me, and obviously you've convinced a lot of other people. I mean, looking at, you know, PMSs signing 40 pages, it's pretty pointless. So the importance of e-signatures and then digital signatures, and how they are even more secure than paper signatures, which as we well know as lawyers can be forged. So with those very brief introductory remarks, may I hand it back to you and wish you all the best for your book. It's a major step, and congratulations.
Really, thank you, sir. Thank you, sir, so much for that. Thank you for laying down the groundwork for what is the importance of electronic signatures in today's date. And with that, Sajan sir, I would now request you to share a few words with everyone here.
Thank you, Anchan and Aditya. First, Gourab, you have been very kind in trying to move me to the 21st century. I don't think I belong there. But yes, jumping just straight from where Gourab left it, our love as lawyers for everything that is physical and for ornate pens and even more ornate signatures. The fact is that one of the easiest things to replicate is a physical signature. Most large chambers would have clerks who could sign in 15 different ways for every lawyer in that chamber, in every wakalat or in every pass that should be issued. The lawyer hardly signed. And if that is the scenario that we encounter in everyday life, why is that we give such prominence to a physical signature, not just in terms of our lives, our documents, what we do, but also in terms of what lawyering we do in court. The fact that a document is not signed or the signatures don't match, we get forensic evidence to it, we get expert opinions on it. Most civil trials take months at end to figure out whether the document is actually signed by a person, whether the signature is interpolated, whether the signature is forged, etc., etc. And all of that happens even today, unfortunately. Most civil litigations are meandering around the physical domain documentation and the problems that are associated with physical documentations, which are plenty. Not realizing the fact that close to a decade and a half, we have had a legal architecture in place, which developed, which recognized and provided as a platform for digital signatures and electronic signatures in particular to be recognized, to be legally valid, and to actually have a technological backing and a recognition within the law, which leads that electronic signature to a methodology where it is, if not impossible, extremely difficult to replicate. If not impossible, extremely difficult to forge. The private key, public key architecture is one of the most tested and well-known architecture world over when it comes to electronic signatures. Most major jurisdictions in the world have accepted it as easily as we have accepted digital payments in this country. If we can pay for our chai on PhonePe or Google Pay or WhatsApp Pay or any of those payment skins that we have on our phones, I wonder why we as a comparatively more technologically visible and sound society as compared to many other jurisdictions in this region of the world, we have still not accepted electronic signatures as easily as we have accepted electronic payments. In fact, possible electronic payments are a little more complex and a little less recognized in terms of its security apparatus as compared to electronic signatures. The security apparatus recognized in the law, the recognition that it gets in terms of evidentiary value under the Indian Evidence Act are actually fantastic, but nonetheless, we have not followed it. I ask myself why. We have not followed it because we, the older generation of lawyers, of which I belong to, I'm inching very close behind Gourab. We have had a problem in terms of our orientation. We have not had the younger generation and the profession demystify this legislation, demystify the technology behind the legislation, and explain it at first blush to the lawyers themselves, so that the lawyer understands what electronic signature is. The lawyer just does not understand the law as it is written, but understands the technology that operates behind the law, so that he or she gets comfortable in terms of what this whole animal called electronic signature is. And kudos to the two of you. You have attempted to do it. And from what I have seen of the book, it is a fantastic exercise in trying. It is actually the young ones who are born, who studied computer science or computer dynamics in the late 80s and early 90s would remember that they were the dummy series. There were Windows for Dummies. There was Word for Dummies. There was Word Star for Dummies, Word Perfect for Dummies. This is actually what electronic signature for dummy lawyers. All of us are dummy lawyers when it comes to technology. And I think you guys have done a fantastic job. Kudos to you. I'll not take more time in terms of deciphering the book, which you will do, but I'll leave you with this thought. As we speak today in terms of electronic signatures, please try and usher in your mind the entire ecosystem which can actually permeate from this. Electronic signatures are the first step towards having an electronic ecosystem for the entire paraphernalia of not just legal documentation, of executing the document, of registering the document. If we can have electronic signatures and we can execute a document electronically, and that is recognized to be a document in law, I ask myself, why can't we register that document electronically? Why can't we have compulsorily registrable documents registered electronically with another set of private and public key from the sub-registrar's office or from the registrar of assurances office, interpolated over the signatures of the parties so that it becomes a registered document, number one. Number two, why can't we have a methodology by which that document can be adduced in evidence in court, again electronically? We don't need to replicate it physically and then bring it into court in evidence and mark it as an exhibit. Why shouldn't a civil court simply mark it as an exhibit electronically by interpolating over the public key of the sub-registrar, a key of the court to say that this is marked as so-and-so? Why should not we have notaries public who can notarize documents electronically? Why should our affidavits actually physically go? Why should the party physically go to the basement or to the boot of a car where the notary public is sitting so that he can append his signature, the notary public can actually notarize it? Why shouldn't international documents be consularized electronically? Why should there be consularized still on paper with a wax stamp on it, with the replica and the flag and etc., and the paraphernalia and the coat of arms of a country? All of these are simple but necessary ecosystems that should actually develop and get into use. The only way an ecosystem becomes strong is by repeated usage in that ecosystem. And you guys have put the first step of making sure that lawyers begin to use e-signatures as often as possible. And that leads to ushering in an entire electronic ecosystem in terms of what we do in our lives. So thank you very much. And thank you for having me here. For me personally, being a technology lawyer, this is actually a watershed moment. Thank God that the two of you have written something which to the first blush looks very simple, but it is not. And therefore, it is an effort to demystify the complex technology behind a digital signature and bring it into public domain knowledge in a manner that a lawyer can understand. And the next step will be, of course, to explain it in a manner that a judge can understand. That's for a later day.
Wow. Thank you so much, sir. Some really kind words, and also for stressing on the need to revisit the importance that we attach to these paper-based physical processes, and whether it's time to actually now move forward to a more 21st century alternative, which are electronic signatures. So thank you, sir. Thank you, Mr. Banerji. Thank you, Mr. Poovayya, for coming for this book launch and launching it so emphatically. So with that, now we'll move to the next part. Aditya, if you would go to the next slide. Yes. So in this next part, designed to give you a useful, actionable framework to evaluate eSign, we will lay down a practical framework to examine the legality of electronic signatures through the prism of two concepts: validity and ease of enforcement. Validity is a question of whether a particular electronic signing method can, under law, be used for a particular document. So there are different types of documents, and then there are different electronic signing methods. So basically here we will list out which eSign method is legally valid for which type of document. And then ease of enforcement or enforceability is a question of how easy or difficult is it to enforce or prove a document in court that has been executed using a particular electronic signing method. I will be discussing the first part, that is validity, and then my colleague Aditya will take over and take you all through the ease of enforcement part. So let's get into it. Validity. When it comes to the legal validity of eSigns, we have often seen that there are some common doubts, confusions, and questions. For example, can eSigns be used for high-value contracts that either you or your clients want to execute digitally? Then there's also the myth that only IT Act recognized specific electronic signatures can be used to execute documents electronically. We'll see why that is not true. And as you can see on your screens, there are some more questions which often in the last few, we've seen them come about often. And by the end of my part on the presentation, or my part of the presentation on validity, you would be able to answer all these questions and more. So validity of a signature type for a particular document is a yes or no question. A signature is either valid or invalid for a particular type of use case. There is no question of being less valid or more valid. Electronic signing methods under the IT Act fit into two tiers. Tier 1 consists of electronic signatures. Now, a point to note here is that electronic signature isn't just a technological term. It is a very well-defined term under the IT Act and must necessarily adhere to the technological standards prescribed therein for it to qualify as an IT Act compliant electronic signature. Some of the common signatures that qualify as Tier 1 electronic signatures are Aadhaar eSign, PAN-based eSign, DSC tokens, and doc signer. Now, tier 2 electronic authentication methods. These methods gain their legal sanctity from Section 10A of the IT Act, which gives us wide latitude to choose any form of electronic media to execute contracts electronically. And some examples of these methods are virtual signatures, click wrap based processes, and even email exchange. So let's look at some of the important legal provisions pertaining to these two tiers, and which also have an impact on the legal validity of different electronic signing methods. First is Section 5 of the IT Act, which draws a legal equivalence between electronic signatures such as Aadhaar eSign and traditional vetting signatures. The key implication of Section 5 is that when a law mandates that a particular document shall be executed using a signature, then to execute that document digitally, you can only use electronic signatures recognized under the IT Act. Tier 2 methods such as click wrap or email will not be legally valid here. Now we come to Section 10A of the IT Act, which pertains to Tier 2 eSign types. What Section A states is that if all the other elements of a binding contract have been met, then the contract cannot be disputed on the grounds that an electronic authentication method was used to execute it. That is why contracts agreed to over email or via click wrap process, or even WhatsApp for that matter, are legally valid. Now, whether you would choose to execute your contracts using these tier 2 methods depends on certain other factors, which Aditya will discuss later on. And just by the way, the US eSign Act also uses construction very similar to this section to give legal validity to eSign in the US. Now comes a real thorn in the flesh for lawyers and businesses. As we just saw, recognition for these tier 1 and tier 2 eSign types as legally valid execution types comes from the IT Act. But Schedule 1 of the same Act lays down 5 types of documents to which the IT Act does not apply. These 5 documents cannot be electronically signed by an IT Act recognized method, like all the ones that we discussed till now, unless there is a special law or regulation apart from the IT Act that allows them to do so. I'll give you an example also here. Housing finance companies in India are increasingly using electronic signatures to get their sanction letters executed electronically. You know, instead of going to the customer's house each and every time just to obtain a signature. But when it comes to the main home loan agreement, they have to get that physically signed because of Schedule 1 of the IT Act, since it is a document that fits into the 5th bucket here. Yeah, and now comes the matrix of validity. This is we like to view this as a cheat sheet that you need to keep with you while advising on the legal validity of different eSign types. All you need to do is see which of the 3 document categories your particular use case fits in. Is it a document which is mandated by law to be signed? Is it one of the documents listed in Schedule 1, or is it neither? Once you know which category your use case falls under, then you can see which eSign type can be legally used to execute it. The second category here, which is Schedule 1, that is just a list of 5 documents which we have seen already. So now let's quickly take a look at some examples of the other 2 categories here. For example, say it's the agreement that a credit card issuing company and a card holder now need to execute between them. This is a new addition pursuant to the new RBI Master Direction on Credit and Debit Cards, which was introduced just last month. So now if the card issuer wants to get this agreement executed electronically because they do not wish to go to the customer each and every time. So if they want to get this agreement executed electronically, they can only use IT Act recognized electronic signatures only. Tier 2 methods like click wrap, email, virtual signatures will not be legally valid here. This is because a law, which is the RBI Master Direction in this case, requires a signature on that agreement. And by virtue of Section 5 of the IT Act, which we just discussed, it can only be signed by an IT Act compliant electronic signature. And there are other such examples as well. For example, a copyright assignment deed. Now let's move on to the final category. For documents which satisfy two conditions. First, that they're not required by any law to be mandatorily signed. And secondly, that they're not mentioned in Schedule 1 of the IT Act. And by the way, this category would form almost 90 to 95% of all document types. So for such documents, you can use any electronic signing type, be it electronic signatures, click wrap, email, whatever. Loan agreements, contract for the sale of movable property, employment agreements, all of these can be signed using any electronic execution method. With this, we have come to the end of my presentation on the validity of different eSign types. But before I pass on the speaking duties to Aditya, let's do a quick recap of some key takeaways that we just discussed. First, validity is a simple yes or no question. All you need is the matrix of validity with you to determine which eSign type can be legally used for which type of document. Second, as we just saw, the legal framework for electronic signing is actually very permissive rather than being restrictive. Almost 95% of all documents can be electronically executed using any of the methods that we've discussed so far. And the last thing you should definitely keep in mind is that electronic signatures such as Aadhaar eSign can be legally used to sign all types of documents, barring just the 5 mentioned in Schedule 1. And with that, we will now move on to the next part of the presentation, the second prism through which you should evaluate eSigns, which is ease of enforcement. Aditya, over to you.
Thanks for that, Ansha. And thank you, Gourab sir and Sajan sir, for the very kind opening remarks. So in the context of what Ansha said, you must be wondering what's the point of different signing types if they're valid for 90-95% of documents. Do you just draw lots out of a hat to pick the signing type that you want to use for a document? But the thing is, and as we all know on this call, validity is not the only criteria to evaluate a signature type or to evaluate anything. That's where the concept of ease of enforcement comes into play. And questions around ease of enforcement are usually the juicy ones, which spark a lot of debate and deliberation. In this section, we will define this debate for you and give you a very easy framework to evaluate the ease of enforcement of a signing type. But before we do that, it's very important to visually model the concept of enforcement, right? In the previous section, we saw that validity was a simple yes or no switch. There's no more valid or less valid. It's either invalid or valid. With enforcement, it's not a yes-no switch. It's more of a spectrum. Some things can be easier to enforce and some things can be much harder to enforce. So how exactly using the spectrum, how do you map out various signing types on this spectrum? And for that, we need to take a step back and realize the role and definition of a signature in the first place. Traditionally, you would define a signature, if you were to ask anyone, they would define a signature as a transcription of your name in a unique calligraphic style. However, when you actually look at the broad swath of signatures that are available, you will realize this is just the definition of a handwritten signature and doesn't include the ultimate role and purpose of a signature. Fundamentally, that role and purpose is 3 things. A signature must ensure authentication, i.e. the identity of the party signing must be clear. 2, it must ensure integrity, ensuring that the document cannot be unilaterally altered after signatures are affixed. And 3, which kind of ties the first 2 together, non-repudiation, that the parties cannot then deny acceptance of the terms and conditions on the document that they are signing at a later stage. In essence, if you were to define a signature, it's any process that ensures all of the above 3 things. So to evaluate ease of enforcement and map it on that spectrum, you simply need to evaluate how well any particular signature type performs these 3 functions. So till now, I've been very abstract, deliberately so, to lay down the basic theoretical concept, and it might seem a bit confusing. So to make it clearer, let's actually try doing a mapping of 3 different but very common signature types against this framework that I just mentioned. To start with, let's start with ease of enforcement of the good old physical signature. How well does a physical signature perform, right? So when it comes to authentication, I'll be frank, it's a mixed bag. Really, the only thing on the bright side of this is that For centuries of using physical signatures, we've evolved science and regulatory legal mechanisms premised on the idea that a signature, handwritten signature, can be unique. But on the flip side, as Sajan sir also mentioned in his opening remarks, a truly committed person who wants to commit fraud can easily learn someone else's signature and forge it. So even though there is a legal regime to catch this actually only happens in court, where you need to call signature experts, you need to follow the evidentiary procedures to do that. And at the end of the day, in the best case scenario, you're still adding friction to your legal proceedings and adding friction to your actual enforcement. Right? Now let's come to the second factor, integrity. Right? We only recognize signatures, physical signatures, as having closed a document by convention. That is, if parties sign, it is a closed contract. And that's why we have the convention of counter-signing any modifications we make on a contract. All lawyers on this call will be very, very familiar with that process. Right? But what you realize is the system is actually just purely driven by convention. In physical and technical terms, there is nothing about this that actually prevents alteration of a document subsequently. So in an age where physical contracts are often scanned and shared over email, the risk is even greater. And finally, non-repudiation. Again, a mixed bag. I would say not very ideal, right? Because parties can contest the signature in 3 different ways that we've listed on screen, right? And maybe more. Happy for any of the lawyers on this call to share if there are any other ways of contesting signatures, right? And the only real thing going in favor of vetting signatures then becomes centuries of us taking them as the conventional mode. Really, if you look at it in physical terms, technical terms, you'll see that even in the best case scenario, they add a lot of uncertainty and friction that we've just taken for granted till today, but we don't need to take for granted going forward. So the verdict on vetting signs, mixed bag with a lot of uncertainty. Now let's come to a very common mode of digital execution called click wrap. If you approve terms and conditions when installing a software, or if you've obtained a credit card through your net banking app, you've likely used click wrap, the I agree, yes, no, tick boxes that you need to do to enter into an agreement. How well does click wrap perform? So on the authentication front, very uncertain. You can point, perhaps at the best case, you can point and say this click wrap was done from a particular electronic device. But the actual identity of the person who clicked yes or no can never be conclusively ascertained or even corroborated. On the integrity front, anything can actually be added or deleted to a document that has been click wrapped. The PDF can actually be edited later and probably easier to edit than maybe even a physical signed document, right? Third, on the non-repudiation front, given that identity is uncertain and given integrity is dubious, it becomes much easier for the other party in an enforcement proceedings to deny acceptance. If you just have a I agree written on the document, you may eventually be able to prove it in the best case scenario, but you'll have to put in a lot of effort to do so. Not very easy to enforce, right? So that's plain click wrap. And I'll be frank, it sounds digital mode, but it sounds even worse than physical signatures when I describe them, right? And then we come to the third one, right? Commonly used signatures, IT Act electronic signatures. This is the tier 1 that Anshat spoke about, right? And to be honest, they are quite stunning. So let's look at the 3 factors, right? In terms of authentication, the secure key pair process that is used and the way that the key pair and electronic signature certificate are actually issued by a neutral regulatory entity called a certifying authority ensures that the identity is quite secure, right? We detail this process of authentication in the book. In terms of integrity, the computational process of electronic signatures currently in India is unimpeachable, right? The public key decryption and hash matching process that electronic signing technology, electronic signature technology currently permitted under the IT Act, which we detail in the book again, ensures that documents are tamper evident. So what does this mean? So let's say I electronically sign a document via IT Act electronic signature and send it to Ansha. If he makes any changes, like removing a page of the PDF, adding even a full stop on the PDF, right? What happens is that the electronic signature will break. So if anyone opens the document subsequently, or if Ansha himself opens the document again, it's going to say that the electronic signing is invalid. The document has been changed, right? This is real-time tamper detection, which is unconceivable in any other signing type. And third, on the non-repudiation aspect, tying the other 2 things together, right? The secure key pair is affixed through a private data that is shared only with the signer. Like for Aadhaar eSign, it's your Aadhaar number and an OTP. For DSC tokens, it's a unique PIN given to you. And second, the asymmetric crypto system can also only be activated by that PIN, which is again in exclusive possession of the signer. Now, one thing you'll notice in this section, I've used a lot of jargon: secure key pair, asymmetric crypto system, certifying authority. And this is not intended to obfuscate or fool you. We have covered these terms in detail throughout the book, Laws of eSign, right? So you can just pick that up for more reference on these terms that I used. Because if I were to explain these terms, we'd probably need a half-day webinar. Now, we've covered 3 signatures: click wrap, physical signatures, and electronic signatures. Now, before I map them onto a spectrum, you must be thinking that it's too good to be true. Like, all the technical benefits of electronic signatures sound too good to be true, right? So I just wanted to, before coming to how we map this on the spectrum, highlight the fact that the law itself recognizes everything I said above, right? The law actually provides explicit recognition to the benefits of the technical framework of electronic signatures that are detailed in the previous slide. How does it do it, right? Let's say, for instance, you see section 47A of the Evidence Act, which says that the opinion of a certifying authority automatically assumes relevancy. So you won't need to justify relevance of the certifying authority's opinion. The law does that job for you and makes certifying authorities an essential part of the process, which no opposite party can deny if you're seeking to prove an electronically signed document in court. Or let's take a look at section 15 of the IT Act, right? And I won't delve into the entire provision here. We do a detailed analysis in the book of how IT Act signatures that are currently sanctioned under the IT Act all meet this standard, right, of secure eSign because of the technological framework that they use, right? Now, IT Act provides explicit recognition to such signatures and says they're secure electronic signatures, right? And now you might say, so what? The IT Act says they're secure. I cannot take this to a judge and say, look, it says secure, so it must be secure, right? In 2 slides, if you give me a minute, in 2 slides, I'll tell you why that matters. But before that, a brief detour to Evidence Act again, section 85A. Here, there's a presumption that any contract that is e-signed is presumed to have been concluded with that e-sign, right? This is IT Act electronic signatures. There are no automatic questions of a non-concluded contract that can be posed easily, right? The burden of proof would be on the party alleging this. There's a presumption that electronic signatures have closed a document that's a contract. And now coming to my favorite provision, and I'm sure this is going to be the favorite provision of all lawyers in this call, section 85B, because this actually gives you 3 critical presumptions in 2 provisions, right, which greatly enhance ease of enforcement of electronic signatures. Section 85B1 presumes that a document has been signed with a secure e-sign, right? It says secure electronic record there, and in the book we analyze why secure electronic record under the IT Act is anything signed by a secure e-sign, right? This provision presumes that that document has not been altered, right? So when I describe to you the technical framework, where if you alter an electronically signed document, it will show up that this document has been altered and the sign will break. 85B1 actually provides legal recognition of that technological benefit. Section 85B2 has 2 presumptions inbuilt in it, right? It says that if a document has been signed with a secure e-sign, there is a presumption of both identity of the signer and intent of the signer to sign that document with that electronic signature. Quite honestly, I have never seen this kind of presumption for any other signing type. And I think it's quite stunning because not only does it prescribe the identity of the signer, but it also prescribes their intent, which would be very useful in contractual disputes. So now, given the technical and legal sanctity given to the security behind electronic signatures in India currently, this is how they look on the spectrum, right? You have vetting signatures there somewhere in the middle. You have click wrap way on the left, hard to enforce, right? Electronic signatures are in effect a leapfrog in terms of security in comparison to anything we've known in India till date, right? Essentially the gold standard of signatures in India and the most secure and easiest to enforce than any other. And this actually puts paid to a very common myth that we receive questions about, right? Where lawyers often think that eSign by default is harder to enforce than physical signatures, and that lawyers have to actually put an extra effort to justify eSign during enforcement. With both the technical and legal framework that we just analyzed, you realize that electronic signatures, that's just not true. electronic signatures are actually a leapfrog in terms of that legal security compared to your standard physical signatures. Now, another myth, something that I think I've been guilty of abetting so far, is that just because electronic signatures are the gold standard, it doesn't mean other electronic types can't get close, right? Because there may be operational reasons which we'll cover in a bit why you can't possibly, like why you can't use electronic signatures, right? So as we saw in the previous section, right, enforcement is simply a function of the technical processes that an electronic signature undergoes to be affixed, right? You can make other electronic types more secure and easier to enforce if you add several security features. I've just listed a few examples here, but you can have probably a dozen more security features that you can add, right? By doing this, you at least bolster the technical process of other electronic signing methods. So you will not have the legal presumptions that electronic signatures under the IT Act have, right? They are the gold standard, but you can definitely move other electronic signing types close to the easier to enforce side of the spectrum so that they're very much harder to dispute in court. So at this stage, I don't blame you because given I've extolled the benefit of electronic signatures, given the Evidence Act has provided such strong legal presumptions, you might be wondering, like, shouldn't you only use electronic signatures when given the chance if you want to digitally execute something? And here I'm going to give you an answer I used to give a lot when I was a lawyer. Honestly, it depends. It depends on various questions, like how many of your potential signers will be able to perform electronic signatures, how big a priority is enforcement, and a dozen other questions. Right? Depends on who you are and depends on what your use case is. But I fear I'm becoming abstract again. So to avoid that abstraction, let's look at two illustrations to help us understand this in a more concrete way. In illustration A, let's put ourselves in the shoes of a microfinance institution wanting to choose an electronic signing type for their loan agreements. Here, our main priority is capturing and recording the consent in a verifiable, trackable way that is palatable to the regulator. Enforcement in court is a distant priority. In fact, for us, it's highly unlikely that we'll be enforcing any of these agreements, right? And operationally as well, there's another concern that our client base may not possess things like even an Aadhaar linked device to even do the simplest form of electronic signature, the Aadhaar eSign, right? So in this scenario, our decision is most likely going to be to go with another electronic signing type that is valid, right? If we are slightly more risk averse, we can add other security features to ensure it has maximum security. But in this scenario, we are taking the call that we don't really need electronic signatures under the IT Act. And in fact, they may backfire for us if we were to put ourselves in the shoes of someone evaluating it for a microfinance organization. But let's take a look at a contrary illustration, illustration B. We put ourselves in the shoes of a corporate finance vertical of a major bank, right? They're evaluating a signing type for secured corporate finance and loan agreements. Here, enforcement becomes the #1 priority because you need this agreement for potential IBC proceedings. And there are hundreds of crores riding on this. There's hundreds of crores of risk, if not thousands riding on this, right? So here, even though it's not mandatory for you to use an IT Act electronic signature, we will likely take the call to go with electronic signatures under the IT Act, like an Aadhaar eSign, PAN-based eSign, or even a DSC token eSign, right? And just to be clear, the above illustrations, I gave you plausible decisions that each of those stakeholders could make, right? They're not the one and only conclusion that a stakeholder can make in that scenario. Some MFIs may be super risk averse and only permit IT Act electronic signatures. And some banks may be satisfied with additional security features on non-electronic signatures, right? And go with a non-electronic signature like a secure virtual signature, right? It completely depends on the legal and compliance appetite of each organization, of each individual. Okay, so that was a lot. And I understand if you didn't get all of that, right? So to clarify and solidify what we've been discussing in the last 20 minutes, let's do a mock exercise, right? If you've been browsing another tab during this webinar till now, admission, I do that a lot during webinars, so I don't blame you. The next 2 minutes will distill the entire webinar. So this is kind of like the cheat sheet for this webinar, right? So let's say a new eSign type is brought to you for evaluation, right? What do? Step 1, you assess whether there are any legal requirements for signing this document, or if the document is listed in Schedule 1 of the IT Act. And when you're preparing your legal opinion or when you're doing legal research on this honestly is a step that will take you the most amount of time. Once you have your answers to step 1 in place, you go to step 2. Refer to the matrix of validity we've given in laws of eSign. And we've given analysis as to why that matrix of validity is the way it is, if you want to see our reasoning, right? If there are legal requirements for signing, right, then the decision is very clear for you. If you want to electronically execute it, you can only use IT Act electronic signatures. If the document is listed in Schedule 1, then most likely the decision is also super clear for you. You will have to go with the dreaded physical process, right? So really step 1 and 2 are filters. If they meet the criteria of Schedule 1 or there's a specific law mandating signature, you can stop the entire evaluation. You can close your legal opinion at this stage itself, right? Because your decision is made for you. But as Ancha mentioned, 90% of documents, there's no legal requirement for signing for signing the document, right? So that's when you really need to evaluate a set of options and actually take the call of what signing type do I choose for this document to do electronic execution. And that's where steps 3 and 4 come in. So step 3, right? What you do is see if the electronic signing type brought to you for evaluation is mapped on the spectrum of enforcement that we've listed and laid down in the laws of eSign book. We've covered most of the commonly used signature, like electronic signing types, like click wrap, virtual signatures, secure virtual signatures, exchange of emails on that spectrum, right? Including a deep analysis of why we mapped each type in a particular location on that spectrum. So if you need that for your legal opinion, you can borrow from that analysis. If you disagree with our analysis, we've laid down how we've come to that conclusion. So if you want to disagree with any part, we made that also easier for you, right? And you simply see if it's mapped. And if the sign type is not there in that spectrum, we've given you the tools as well, right? Simply do an evaluation of that type based on how well it performs the 3 functions of a signature we listed out, right? We mentioned these 3 in the book as well, so you can easily refer to them for a DIY evaluation. So, right, step 1, 2, 3. At the end of these 3 steps, you will have 1, a clear answer on validity, and 2, a clear answer of where the signature type falls on the spectrum of enforcement. How hard, how easy is it to enforce? And then comes the all critical conclusion, section 4, right? And at this point, honestly, it's based on your operational compliance and enforcement priorities. Based on these priorities, you will need to take the final call. In-house counsel on this call, you in conjunction with your business teams, your operations teams are best positioned to do this. People in law firms and litigators on this call, you can definitely recommend things on the basis of your analysis of steps 1, 2, 3. But the final decision fundamentally of step 4 is in the final hands of the company, organization, or individual who will finally use that eSign type. And that's where operational and business considerations also come into play and, intersect with the law, right? All right. So that's the session. Hope you enjoyed it. Before we move into open Q&A, I'd just like to share a small insight from my end. What often happens to me is that 5 minutes after events like this, I forget everything. Right. But in this scenario, for this event, that's not an issue because everything we've covered is laid down in more detail in the laws of eSign book, which we just launched at this event. Now, how do you get this book, right? Once this webinar ends, you will automatically be redirected to the book access link, right? But in case you are not, simply go to the URL mentioned on screen, which will also be dropped in the chat window below. Right? The book lays down everything we talked about with deeper analysis, relevant legal provisions, and also case law where applicable and where available. Right? So whenever you need to do a legal opinion on an eSign type, keep this handy and it will be a breeze. We're dropping these details again in the chat. Right? And finally, before we dive into the Q&A, a shameless plug for a new initiative we are launching, the e-contracts hub. A one-stop repository of resources for lawyers about eSign, digital stamping, electronic evidence, and e-contracts. Right? Here's the URL. We'll drop that in chat as well. So if you want periodic updates, you can subscribe to the e-contracts hub on the page itself. You will get notifications about new articles, webinars, and also our upcoming books. Because yes, there is more in a few months, and we'll announce the date soon. We'll be launching laws of digital stamping. A deep dive into the technical and legal framework behind another hot topic, digital payment of stamp duty, something that's probably even more controversial than electronic signatures. So stay tuned for that. We hope to announce the release date of that soon. We're working on it in full earnest. All right. Now that was the session. Now it's time to get to your questions in the open Q&A. So we have 4 questions here, and we have a few questions that people emailed us in before the session because they said they'll only see the recording and won't be able to attend. Right. I think the first question is a scanned wet signature, a valid signature recognized under the IT Act. Is there any jurisprudence validating such signatures affixed on electronic documents? So I think that's very easy. It would fall under 10A. So while it doesn't perform the technical requirements and the regulatory requirements for electronic signatures under the IT Act, it would fall under tier 2, other electronic signing types. Right. Now the question is, how are you going to prove it in court? That depends on how you're affixing this. And with what security features are you affixing this so that it cannot be disputed in court? Right. That's the first question. The second question that we've received, and Gourab sir, I'd like to bring you in here. A question on section 65B, and we actually receive this in all webinars. So does section 65B, I mean, beyond being a procedural provision, is there anything special to keep in mind for section 65B for any of these electronic signatures if it were to come to that?
I'm not sure that there's anything special above and beyond what there is in section 65B, but you have already mentioned the relevant provisions of the IT Act. 65B is essentially a method of proof, but so far as electronic signatures are concerned, there are specific provisions of proof which you've already shown.
Thank you, sir. Exactly.
Aditya, if I could add here. I see Ankush has asked this question. Ankush, if you want more an in-depth analysis of the role section 65B has to play while adducing electronic agreements in court which have been executed using electronic signatures, please refer to chapter 9 of the book, where we detail the entire legal analysis of section 65B. A pertinent question here you might ask is, who will give you the 65B certificate? Do you need the tech platform to give it to you? The answer is no. As long as you have a copy of the electronically executed agreement, you yourself can adduce the 65B certificate. And the book also has a sample indicative 65B certificate that you can use.
Right. And we have another question, digital signature versus electronic signature. Very common question that we receive, right? The IT Act makes no such distinction. In fact, the IT Act in an amendment has actually changed all mentions of digital signature to electronic signature. What we conventionally know as digital signatures is the asymmetric crypto technology, is a technological framework, right? But the IT Act has basically made all electronic signatures follow that framework and has deemed them to be all, like, has changed the name actually of everything to be an electronic signature. So if you see the IT Act definitional clauses, and we mentioned this in the book, where it says what is an electronic signature, it says an electronic signature is a digital signature under section 3, which was there before this amendment, where BSC tokens were legalized in the IT Act. Section 3 and also Schedule 2 electronic signatures, which was a subsequent amendment that brought in things like Aadhaar eSign. So as far as the IT Act is concerned, as far as Indian evidence law is concerned, there is no material difference. In fact, explicitly, there's no difference because the amendment has specifically changed all mentions of digital signature except in the definitional clause to be read as electronic signature.
So just to add to what Aditya has said, so while there is no difference in the underlying technology that a digital signature and an electronic signature uses, there is a completely different regulatory framework for electronic signatures. There are different players involved here called an ASP, ESP. There's too much detail to go into right now, but there is a separate regulatory framework specific to electronic signatures, which is again detailed in much more detail in the book.
But in terms of validity and enforcement, there is no real distinction. It's just a matter of how you procure the two, right? So Sajan sir, there's a question we received on email. So I'll ask that before moving on to the next question here. Is while the law gives these presumptions of validity, and the technical framework is also quite beneficial in favor of electronic signatures, lawyers will still have to go out there and convince judges or clarify these concepts to judges. So are there, when bringing new technology, relatively new technology before courts, before regulators, are there any useful tactics or things to keep that lawyers should keep in mind when actually just educating adjudicatory bodies of what's already there in the law, especially when there's technical concepts involved?
Aditya, that's a question which actually is pertinent not just for eSigns or electronic signatures. That's a question which actually permeates through any technology litigation that is brought to court. The one thing that we should always remember is, if you want a tribunal or a court or a bunch of judges on the bench to understand what you are saying, it's very important for you to demystify technology first to those judges. The biggest mistake I think we do as lawyers is we follow the traditional wisdom path of trying to read the law first and tell the judge what the law is and then tell them how it applies to your fact, which is really not what you should do in a technology litigation or in a technology question before court. It's important for you to actually demystify the technology behind what you are saying first to a judge. Make it as simple as possible, and you have enough tools to do that. You have enough material that is available which spells and explains technology in a non-technical language to judges, and then over that superimpose what the dispute is and what's the document that you're bringing to record. I'll just take one anecdotal scenario. In the mid-90s, there was a lot of litigation which pertained to emails. This was before 66A actually vanished, etc. This is the scenario even before 66A came into the statute book. A lot of litigation on defamatory content, etc., available through emails. A task that we had as lawyers then was to explain to many courts in the country, and I'm not looking at the Supreme Court and the Delhi High Court. They are all technological savvy. I'm looking at the sub-judges court in Manjeri in Kerala. I'm looking at actually the civil judges court in Silchar in Assam. Those were courts in which you are trying to actually explain to a judge how emails work, how that mail is even sent. How can an email actually at the same time reach 15 recipients instead of one by a click of a button? We had those problems. Today, no court will ask you that question because they understand how that technology works. So the key is, when you are bringing a new concept into a court and you believe that the court does not appreciate that concept, is to first demystify technology to court and then bring the law as a superimposition over it.
Thank you, sir.
Just to add, you need time. You need to spend the time to understand the technology and then to demystify it. So the lawyers also require to spend the time to actually simplify matters. Looking at for instance, your presentation, you have to understand the subject first, make the effort, and then you will get the result.
Thank you, Sajan sir. I think Sajan sir has to leave, so thank you so much
Thank you
for attending, and thank you so much for being here. I really appreciate it. Thank you.
Thank you, sir.
And thanks, Gourab sir, also for that intervention, because we often find lawyers, when they encounter technology, they just ask for a cheat sheet or say, like, this technology, like, just tell me the law behind it. Don't take me through the intricacies of the technology, when actually they're intertwined. And if you see the IT Act construction, it actually uses technical jargon when describing this, which is often what leads to confusion when lawyers also pick up the IT Act to actually read these concepts. So actually this understanding, a tech understanding of what the law is saying, is super critical, again, not just for eSign, but probably anything that's under the IT Act or any legal concept or legal process that now relies on technology. So I think there are two final questions. One we've received on email, one that has been answered in the chat, asked in the chat box as well, regarding virtual signatures through international platforms. And these are very common, right? And we've received this question via email as well, right? What's the like, would virtual signatures through international platforms, which are which are electronic signatures in American law, which are electronic signatures in European law, would they require technical analysis to conclude whether they are valid and enforceable? So that's the question, right? Like your DocuSigns of the world, right? So two parts to this answer. For validity, they don't require technical analysis. You just need to see whether the law mandates that the document requires an electronic signature or not, or a signature or not. And if it does require a signature, then you can't use them because they're not IT Act electronic signatures. Two, if it's under schedule 1, obviously your decision is made for you on validity. If it's not, validity is of course for 90% of documents a yes, because any electronic type can be used. Second, on enforceability, again, you will have to follow that process, right? You'll have to see what security features are there. You will have to do a basic technical analysis, and you will also have to map out how you're going to actually enforce it in court. What type of document is it? What regulator is it going to come before? What court is it going to come before? What is the level of the audit trail? Will I be able to show and map out the validity to a judge? Will I be able to prove identity to a judge? These are questions you'll have to answer when it comes to enforceability, depending on your document. So yes, for enforceability, you will need to do a technical analysis of these types. And again, it will depend on your use case, depending on what type of document you're using it for. So another question about stamp duty. How do we take care of stamp duty when an agreement is executed through eSign? So the short answer is you can wait for laws of digital stamping. The long answer, or the slightly longer answer, is there is a legal framework for digital stamping. So if you go to the e-contracts hub, which is we'll drop in the chat, there are some articles on what types of ways, like what ways are there to pay stamp duty in India, and how you can actually digitally stamp documents, right? Slightly longer answer, the stamping laws themselves don't mandate that it cannot be paid digitally, but they do require defacement of stamp paper, right? Defacement of stamp paper in the way you receive stamp paper. And Section 4 of the IT Act says that whenever you want to make a physical document digital, you need to ensure that the physical copy is also available and identical for subsequent reference, right? So these two basic criteria, and in the articles we've gone into how these criteria play out in the ground. These two criteria need to be met for you to do digital stamp duty when it's executed through eSign, right? So there is a legal intricacies involved around digital stamping, which will be there in the next book. But for now, in the e-contracts hub, we've actually detailed some of these, and we've detailed how exactly you can do legally valid digital stamping. If you want more on that, you can also reach out to us offline, because I didn't want to do this in the session, but a small 10-second plug. We do digital stamping as well as part of our product. So if you want to know more about it, you can reach out to us offline. But also the e-contracts hub has neutral legal analysis of this issue as well. Another question we just received around the reliability of eSign and how to overcome such a concern. I'm guessing this is a question on ease of enforcement. So I'll quickly answer this, and Ancha, you can come in as well. So as you see, for electronic signatures under the IT Act, the technological framework is very solid, and the Evidence Act actually recognizes these technical frameworks and gives presumptions in favor of these signature types, right? So you really just need to take the judge through, as Gourab sir and Sajan sir said, you need to explain to them the technical framework and how it meets the 3 goals of a signature, and then bolster that with what the law actually says and sanctifies under the Evidence Act and the IT Act. Anja, do you want to add anything?
Yeah, Aditya, not much to add there, but Shubhang, to answer your question, this concern, we've seen this concern. A lot of people have this concern. But as we detailed in this presentation, this concern is mostly unfounded because of what Aditya said. It's electronic signatures are technically superior. Just the fact that, you cannot alter a document after it has been e-signed, that's something really stunning, right? So now you know that technologically it's superior. Legally, this technical superiority is also legally recognized. So if your question is just about how it's going to play out in court, we just have to listen to what Mr. Banerji and Mr. Poovayya said on how to just convince judges of this technical superiority, which is also legally recognized.
Right. I mean, 20 years back, we weren't using emails as evidence in court. Now emails you can see in High Court, Supreme Court, and in district courts all over the country, right? And judges look at it without batting an eyelid, right? For electronic signatures, it's even easier because there are actual Evidence Act provisions. With emails also, actually, there are some Evidence Act provisions. With electronic signatures, there are more such provisions. Right. I think we've answered all questions. I think there was one question, yes, we received on email. If a document is physically signed and e-signed, what happens then? Well, the electronic signature, that's a very simple answer. The electronic signature is governed by whatever laws govern electronic signatures. And if there are presumptions of validity, it will be favor of that type of signature. And physical signature would be governed by whatever laws, i.e. none really under the Evidence Act that govern physical signatures and their validity and ease of enforcement, right? If you have to prove it in court, there are procedures for handwriting expert and things like that. So really, there's no legal validity issue there. You can it's perfectly fine for someone to physically sign it and for someone to digitally sign it. In enforcement, the electronic signature will be very easy to prove. The physical signature might be easy to prove, might not be. Again, depends on the document in question, depends on the case in question. If you were to ask my personal opinion, it would not, I mean, ideally both should be the same format, but in terms of legal law, there is no bar on you having different types of signature.
Aditya, there was also one question we received before the webinar. The question was that if a document has been e-signed, do I need to execute it physically also? It's a very simple question with a very simple answer. No.
Yeah.
Yeah, just no.
You don't need to. That would be like e-filing systems in courts where you have to scan it and then print it and file it. But unfortunately, the law of eSign and the IT Act does not prescribe that. Right. So thanks everyone for your attendance. We had a great number of people attend today. Great number of people who sent us questions in before the call. Again, you will be redirected to the book access link. The book will be available. You can reach out to us on the eContracts Hub page. You can also get access to new books that we publish if you sign up for the email list. You can reach out to Ancha or I on LinkedIn or on any other forum. All right, feel free to reach out to us if you have any questions. If you have any questions about the book, you can also reach out to us on lawsofesign@legality.com. So if you have any questions, feedback, disagreements, comments, please feel free to write to that email and we will definitely reply to you. Beyond that, Gourab sir, once again, thank you so much for both the foreword at the beginning of the book and for your kind remarks and key interventions in this session. So once again, thank you so much for taking out time.
Thank you so much, sir. Thank you.
Well, I must say this, that I have learned a lot as well. And particularly your presentation summarized the book better than the book. Thank you for being, thank you for keeping me here. I will bid my
All right, sir. Thank you so much.
Thank you.
And for everyone else on the call as well, thank you so much for attending and hope you enjoyed the session. And again, feel free to reach out to Ancha or I or write to us at lawsofesign@legality.com. With that, giving 30 seconds for any more questions.
Oh,
okay, there are two more
question.
questions. Okay, one question is, can a single document be physically signed by one party and digitally signed by another party? As I answered, yes, that's possible. You can do it. You just have to see in enforcement what you're going to do about it. The second is any potential fraud. The fraud is potential, like with electronic signatures under the IT Act, very low, very, very low, given the technical framework that they operate under, given the presumptions of validity that are there in their favor under the Evidence Act. So it's the lowest possible it can be with IT Act electronic signatures. With other signing types, honestly, it depends on the security and fraud prevention features you have in the process, right? And often when comparing, always hark back to what you're moving from. You're moving from physical signatures, where there are actual provisions in the Evidence Act foreseeing scenarios where fraud allegations will be made in court and what to do in such scenarios, right? So you're moving from a system which is very susceptible to fraud in any case, as Gourab sir had mentioned in the opening remark as well. But if you're using an electronic type that is not an electronic signature, honestly, it depends on the procedure. And of course, if you're using an IT Act electronic signature, there are technical safeguards and there are legal safeguards. So it's probably the least fraud possible that you can ever have with any potential signing type. Right.
One more question, Aditya. Is it legally valid to fix an automated e-sign to documents in bulk?
Automated. I mean, absolutely. Absolutely, because that falls under Section 10A of the IT Act, right? It's another electronic authentication method. And if you can prove that that electronic signing type was affixed by, if you're doing it automated, I'm assuming on behalf of an organization. If you're doing that, then like it shouldn't be an issue. Like if you can show that the automatic signature, like if you can show an audit trail showing where the automatic signature was done from, it won't be an issue at all. One more question. Did Ancha, you want to take this one? Asked by Tejesh in chat.
Yeah, okay. Did your presentation cover, so I'm just reading out the question. Did your presentation cover eSign on pleadings like plaints and written statements to be filed in courts? So again, Tejesh, as we discussed, you just have to do the validity exercise. Do pleadings, from what I understand, pleadings and plaints and written statement definitely do not fall under Schedule 1 of the IT Act. So these can be electronically executed. So you just need, so which type of electronic execution mode you use depends on just one point of research that you need to do. You just need to see, do pleadings and plaints, are they required under any law to be signed? If they are, then you can only use IT Act recognized electronic signatures, such as Aadhaar eSign, PAN eSign, or DSC tokens. However, if that's not the case, then you can also use virtual signatures and secure virtual signatures as well.
Right. And I do know for a fact that eSign has been used for things like insolvency petitions in court, insolvency plans in court. It's been used for memorandums of settlements in the district courts and in high courts. It's been used for things like shareholder agreements, which have then become part of proceedings in court. So it's not common practice to eSign pleadings unless there's digital filing. But under the law, there is no bar unless there's something special in maybe the court rules of that particular court, right, which specifically prohibit it. And again, in the initial days, you may have to convince the registry in some courts, but legally speaking, I don't see a bar, with the caveat that I have not read in every single court procedure for courts around the country. So like the court rules of civil procedure and court rules of criminal procedure, right? Like they have guidelines on filing. So with the caveat that I don't know what those say in different states, in the law as we know it, apart from those documents, should be fine if you can convince the registry. Ancha, any closing remarks from your end?
There's actually one more question that has come in. Any recommendations as to what amendment to the current IT law should be made to make it a more robust mechanism? Shubham, to answer that, it is actually a very robust mechanism in terms of the technological standards prescribed in and the legal safeguards. However, we do wish for some amendments in order to expand the scope of electronic signatures as well, And we see, for example, if you take Schedule 1 of the IT Act, which lists out 5 documents and puts it outside the purview of electronic execution, we see businesses facing a problem because of that every day. Stockbrokers across the country, they have to get powers of attorney signed from their customer, while they're able to electronically execute everything else that they need from the customer. However, a POA can still not be electronically e-signed. So as to what amendments we'd like to see in the IT law, definitely reducing the number of documents listed in Schedule 1, or even doing away with it completely would definitely be a good move.
Yeah, definitely. Because even 50 crore insolvency resolution plan or 1,000 crore insolvency resolution plan can be e-signed, but a 2 crore trust deed worth 2 crore house, like home loan, like say home sale deed, cannot be e-signed. So it's a kind of anachronism why some of the things in Schedule 1 are there. That's of course our opinion, but that would be our main recommendation. In terms of anything else, maybe like a very selfish recommendation is include our matrix of validity as an annexure, but no, it is quite solid. All right. With that, Ancha, you have any closing remarks?
Yeah, I just hope that everyone found this useful. We've advertised this everywhere that we're going to give you a useful, actionable framework. And I really hope everyone found it to be that, and that you can use this in your daily legal advice. And thank you all for joining. This was a great turnout with a very engaging audience. And so it was fun to be on this side as well.
Yeah. And please reach out to Ancha primarily for all your doubts. He's the one who primarily wrote this book. So if you were to choose between us who to bother, please reach out to Ancha for sure.
I mean, Aditya doesn't like to take credit.
Thanks all. So we'll send the presentation across with the email within 48 hours of this event. We will send the presentation. So, but something better than the presentation is the book, which you will receive right after this event. With that book, we will also publish a primer on how the key pages in the book, which talk about key concepts. So we will publish that online soon as well. And probably you'll receive that in the email as well within 48 hours, kind of a primer on where to look in the book for certain key concepts. Great. Okay, something final in the chat? No further questions. Again, if you have questions after this event, also reach out to Ancha or I. Write to us at lawsofesign@legality.com. We will get back to you very quickly with questions, doubts, criticisms that you have. Thanks all.